Hey y'all, Knox here with the American Suppressor Association, and welcome to the March 2025 Suppressor Policy Update. This month has been an absolute roller coaster for the suppressor community, complete with action in the legislatures, the courts, and the Trump administration. We are still waiting for a response from the Department of Justice to the first pro-Second Amendment executive order in history, but nonetheless, if there's a theme for this month, it all centers around one question: are suppressors covered by the Second Amendment? You know exactly what we think, but let's dive in to see where things stand. On February 6th, a three-judge panel in the Fifth Circuit issued a ruling in U.S. v. Peterson stating that suppressors are not arms and therefore are not protected by the Second Amendment. To recap our position, we absolutely could not disagree more. Suppressors are in fact arms, especially when you consider that the act that is restricted is the use of a suppressor in conjunction with a firearm. Let me put that in perspective. There are no restrictions on the use of suppressors for automobiles. In fact, their use is required. We may not call them silencers or suppressors, but at the end of the day, a muffler is the exact same thing, just used in a different application. Shortly after the February 6th decision, the Defendants Council brought on Cooper and Kirk, the same law firm that the ASA Foundation and Silencer Shop retained for the legal challenge to the ban on suppressors in Illinois, to petition the Fifth Circuit for an en banc review. If you're not familiar with en banc reviews, it's basically a special procedure used by the courts to engage all of the judges within the circuit to review the case at hand. Well, on March 17th, the acting U.S. Attorney for the Eastern District of Louisiana issued a response in which he argued against the petition for en banc review and asserted that suppressors are not arms and therefore should not be protected by the Second Amendment. Needless to say, we immediately pushed back, asking the administration to reconsider their position. As if on cue, on March 18th, ASA General Counsel Michael Williams participated in a litigation update on the Peterson case with the Federalist Society, during which he explained the many reasons why suppressors should be protected by the Second Amendment. It's about an hour long, but trust me, it is well worth the watch. Well, it appears that someone within the Trump administration thought so too, because following our calls for the DOJ to reconsider its stance on suppressors, on March 20th, the government filed a new motion asking the court for a 30-day delay on the ruling for en banc review to give the government time to reevaluate its position. Fast forward to March 24th, and Chad Mizell, Chief of Staff to Attorney General Pam Bondi, put out this tweet on X: "Protecting the Second Amendment rights of law-abiding citizens is a high priority for AG Pam Bondi. To that end, the department will be reevaluating some of its recent litigation positions on Second Amendment issues, including silencers." I'm not sure it's possible to underscore how big of a win this is. The Chief of Staff to the Attorney General put out a public statement acknowledging that the DOJ is reevaluating its position on suppressors. If you would have told me 6 months ago that this would happen, I would have told you you were crazy. And thankfully, I would have been wrong. Our community owes Attorney General Bondi, Chad Mizell, and the Trump administration at large a huge debt of gratitude for their leadership prioritizing our Second Amendment rights. It is truly a refreshing departure from the previous administration, who did everything they could to restrict and erode our constitutionally protected right to keep and bear arms. Speaking of which, on March 26th, Vice President JD Vance got out to the range to enjoy the benefits of shooting with a suppressor. As a veteran of the Marine Corps, the Vice President certainly knows his way around the M4 platform, but I for one will never grow tired of seeing our elected officials send rounds downrange with suppressed guns. Every law-abiding American should have the right and ability to use suppressors to protect their hearing. It's nice to have an administration that seems to agree for a change. Serious question though, do you think Vice President Vance knows how long it takes to transfer a suppressor? According to ATF, for the month of January, E-Form 4s averaged 42 days for individuals and 48 days for trusts. Fast forward to February, and those averages dropped to 24 days for individuals and 34 days for trusts, with a median processing time of 17 days. As of March 31st, the wait range for Silencer Shop customers is 1 to 16 days, with a median of just 3 days for individuals and 6 days for trusts. Remember, ATF doesn't run the NICS checks for NFA items, the FBI does. And because the NICS checks for NFA items aren't subject to the Brady Act, the 3-day statutory requirement to process the NICS checks also doesn't apply, meaning the FBI often takes their time processing background checks for NFA applications, even though it's the exact same check for rifles, pistols, and shotguns. We are actively working to try and A, remove suppressors from the National Firearms Act because it's a ridiculous law that never should have existed in the first place, and B, in the meantime, eliminate any delays to the process because there's no reason why in 2025 it should take more than a few minutes to process a simple application. Acting Director Patel and the administration could make a tremendous splash by simply requiring the FBI to treat all NICS checks the same, regardless of the type of application they're being used for. It's part of the package we're asking the administration to act on, and hopefully soon we can expect some positive movement for suppressors. Without dollars and cents, the American Suppressor Association would not be able to fight for your suppressor rights. In March, Daniel Defense committed $30,000 towards ASA's efforts. Marty Daniel, founder of Daniel Defense, serves as a mentor on the ASA board of directors, helping us navigate the complex world of politics and Second Amendment policy. To Marty and everyone at Daniel Defense, thank you for your support. We wouldn't be where we are without you. As one of the nation's leading firearms distributors, Lipsey's has a long-standing reputation for industry leadership and a deep commitment to advancing suppressor rights for law-abiding citizens. This year, they stepped up big, increasing their sponsorship of ASA to $20,000. Lipsey's has been a longtime integral partner in our fight to protect and expand suppressor rights. Their decision to increase their sponsorship this year underscores their commitment to advancing our mission to make suppressors legal across the country. Special thanks to Lipsey CEO Laurie Aronson, President Mark Emone, and NFA lead Scott Dewey for going above and beyond once again. In case you don't remember, on February 3rd, the Ninth Circuit issued an order indicating that it would likely appoint pro bono counsel to Gary Sanchez, a pro se litigant challenging the ban on suppressors in California. The case, Sanchez v. Bonta, was initiated by Mr. Sanchez after he was denied permission to make his own suppressor. Cooper & Kirk, the same law firm retained by the ASA Foundation and Silencer Shop for Anderson v. Raoul, reached out to Mr. Sanchez. After speaking with him, he agreed to let Cooper & Kirk represent him alongside the attorneys for the California Rifle and Pistol Association. On March 28th, they submitted a 51-page replacement opening brief for the case, arguing that suppressors should be protected by the Second Amendment and that the ban on suppressors in California should therefore be overturned. There's still a long way to go in this case, and we expect the Ninth Circuit to put up one heck of a fight. Nonetheless, we remain highly optimistic that suppressors will come out on top. On March 28th, the Montana House Taxation Committee held a hearing on House Bill 854, an initiative introduced by Representative Lucas Schubert to create a $50 refundable tax credit for NFA transfer taxes paid in the same tax year. ASA Vice President Owen Miller testified in support of the bill alongside the NRA and numerous Montana residents, including one very well-spoken 14-year-old who utilizes his father's suppressor to protect his hearing while hunting. On March 31st, the committee voted on the legislation where it was shot down by an 11-10 margin. The objections seem to come from members who feel that it is incumbent upon the federal government to abolish the tax entirely. On that point, we certainly agree, but it would have been nice for the law-abiding residents of Montana to have an offset to the onerous $200 tax to protect their hearing. Well, that's all we have for this month. If you like what we're doing and want to support our work, click the link below or visit us at asamember.com. That's asamember.com to join or donate to ASA today. As always, thank you so much for tuning in. We'll see you again next time.